he'll be out of there in a second. Okay.
I am going into the Court of Special Appeals to get a copy to see the record extract in the file so that I can verify that the record extract has been received and docketed at the Court of Special Appeals in Maryland, because the 60-day period for filing my appeal started on December 31st. But I was informed that the record is missing from the Court of Special Appeals, but I'm still responsible for filing my brief, and I can't file a brief.
What day were you informed? What was the date?
Yesterday.
Yesterday, that was the 20th or 21st?
December 21st.
January 21st.
Right, January 21st.
2004, okay.
The brief was not in the Court of Special Appeals, and nobody knew where it was. So I just left the PG County Circuit Courthouse to verify and get receipt of mailing confirmation that it was actually sent, which I did get certified true copy. I also found out that the record extract, when the notice of mailing was sent to me, it was returned to the court for insufficient return to the court.
For insufficient funds once again?
For incorrect address.
Didn't they do that to you at the last third time, right?
This is the third time.
Okay.
Since I filed the appeal that I've had problems with mailings from the court, PG County Circuit Courthouse.
Well, it's obvious they're trying to keep you from getting any information out of this court. So
what I've done is I prepared a motion to ask for an extension of time in filing my brief if the record extract is not to be found at the Court of Special Appeals today.
Well, let's go on over there and see what we can do, okay?
Okay.
That's fine. It should be, we'll seal on the docket and seal on the opinion. Sounds good to me. 1961-01, as you said, right? Can you believe that? Well, so much for public records and courts of record. Oh boy.
So that means that I still have to move forward.
You have to move forward to protect your rights. You have to move forward.
They have to actually file it with my copies of my documents that they don't have.
It's always the best thing you should do is supplement make your own record extract.
Okay, which I do.
Yeah, I mean you always need a record extract.
I have my own.
Yeah.
I have my own, and in fact I've done most of everything.
Yeah. Because you can't rely on them to go through and to find somebody else's stuff to file, but I hope it gets distributed, because the photo here shows that they're not being distributed. But I think since you won several times already, he was a joke in that hearing.
My battle is not with the lawyers anymore.
Yeah, he robbed my wife too. He robbed my wife. Just as if he put a gun to her head and stole everything she had, And I don't try. Yeah, there we go. We'll do a little interview with Shirley on the way over. Well, Shirley, we were in there, and you couldn't find any of your records. What do you think of this?
I think it's a disgrace that as a city record, and at least we...
Secret Justice Productions proudly presents Predatory Lending 101. The cause and effect it has on our society as a whole and how our citizens are being ripped off by predatory lenders. This documentary is being produced for production to the Maryland members of the Maryland General Assembly so that they may address once and for all the legal misconduct of predatory lenders who are using our courts to steal our citizens' property without due process rights under the law. Predatory lending starts with a faulty loan document conceived in fraud meant to take advantage of the undereducated and unknowledge people of this nation. We will be right back with our show.
We'll never be defeated. The people united. We'll never be defeated. The people united. We'll never be defeated. The people united. We'll never be defeated. The people.
As the General Assembly contemplates the passage of a predatory lending bill, Acorn is in the forefront of this fight. Nationwide, we are trying to get predatory lending laws enacted to protect the majority of our citizens.
Put this predatory lending scheme together that hired all these law firms that propped him up and covered for him and aided and abetted in this scam, predatory mortgage scam against homeowners, black and white, in Montgomery County, PG County, in Virginia, and Washington, D.C., that the federal government did nothing, but it was left up to me to get redress and to get those mortgages paid off. That they were involved with Michael Klott back in the 80s in another predatory lending scam that involved just about every U.S. attorney in the country. That
Michael Klott was involved with previous,
and these law firms. Michael Sundermeyer at Williams and Connolly was involved. Richard Bennett at Miles and Stockbridge was involved. The law firm, so that they were on notice, and they were involved in a previous scam where the law firms, the people tried to sue them, but the government backed away.
Well, Shirley, we're back here again now.
In the previous scam.
Excuse me for stepping away. Okay.
In the previous scam, that when I went to Philadelphia and went to the archives doing my research and background to find out what did Michael Klott do, and I found out that two of the law firms were involved in the previous scam back in the 80s, and homeowners tried to sue the law firms who were defrauded, but they walked, the law firms, but I'm the only person that stood in the way this go-round of the law firms getting off free and clear of being involved in racketeering activities and money laundering for criminals. And they're just as criminally liable because they knew it and they did nothing about it.
Oh, absolutely.
They aided and abetted, and then the judges have been protecting them from me. They even made Michael Klott disappear in jail.
Yeah.
And he's serving 12 years without a chance of parole.
He's not serving 12 years without a chance of parole because the judges in Prince George's County have this wonderful law. And Michael Klott obviously has money. Mm-hmm. We are the most backward state in the nation. There's only one other state in the nation that allows 3 judges to get together anytime within 1 year after someone is sentenced for any crime, and they can vacate the crime, and they can nullify the judgment, and they can expunge the record in secret. And the people of Maryland are being terrorized by this loophole in our judicial system that the members of the Maryland legislature are letting them get away. Right now we're being terrorized down in Annapolis by a disbarred attorney, Briano, who has repeatedly violated the rules, but the courts are still allowing him to access to our legislators for his dastardly deeds. And this is sick. This is sick.
But what people need to realize that even though I owned a mortgage company, I've never been a criminal. I've never been indicted. They haven't even called me to give testimony before a grand jury. And I feel that if it involves my company, I'm president, I'm the one person that they should have been calling. So I call this jury avoidance, when prosecutors know that you have information that would incriminate somebody. They deliberately ignore you so that they never have to present that information to a grand jury.
Yeah, but see, on top of that, they not only...
I call it jury avoidance. Like prosecutors say that there's jury nullification, where they say a jury ignores what they're doing. Well, prosecutors do jury avoidance in order to keep people that really should be indicted and going to jail, not making that information known so that they avoid criminal prosecution.
Well, the reason for that is it's simple. It's easier to take a black man who's out on the street, or a minority or disadvantaged person who has little income or ways to defend themselves, and if they do as much as steal a $10 item from a department store, the justice system will trip over backwards to prosecute that man and put him in jail. Yeah. But you have had tens of millions of dollars taken from you. Yes. I have had tens of millions of dollars of my and my partner's assets taken from me. And we cannot even get the benefit of a trial.
We can't even get the government to investigate and say, even when we give them the documents.
The government will not investigate because it involves getting into misconduct, and once they find misconduct, then it opens the way for all these other people who have been wronged to come back and seek redress, and they don't want to do that. So it's easier to take persons like yourself and myself and just say, well, you know, you're victims. You know, Larry Klayman of Judicial Watch, I sent him the documents, I showed it to him, and they read it, and then they called me back and they said, well, you know, Mr. McDermott, you might as well get used to it. Sometimes, even when you are right, you have to lose. Now,
good thing. That's like saying good things happen to bad things happen to good people, and people say you must have done something for those bad things to happen.
Yeah. So
no, you don't have to do things, anything bad, in order to be set up and terrorized by the system that's designed to protect your rights.
Right, and you're not the only one. I run into when I'm down at the courthouse with my truck. Every time I'm down there, I get another call from somebody who's seen my truck.
It's too common.
And they asked me, what's it about? And I give them, and I direct them to my website, and I said, here are the documents. They're on my website. This is the law that will help you. That's the reason www. Fraud Victim was created, so that everybody who has access to a computer or access to a public library will give them access to a computer. They can get on there and they can see the record of how egregious these court rulings are, and they can see that the substantial law that has been put into the record, that this will never disappear, folks.
George, you said something about, did you say 98% of the cases are dismissed in the Court of Special Appeals?
Yes, Shirley, I did. I said that 98% of the cases are dismissed in the Court of Special Appeals. Same thing in the Court of Appeals. Same thing in the United States Supreme Court. Supreme Court gets about 7,000 to 8,000 cases a year. They only cursory review maybe 300 of them. The remaining cases are allegedly dismissed. And I asked the clerk of the court how to, what the process is. I said, can I get a copy of the transcript of the proceedings of the Supreme Court? Because my case was allegedly dismissed in the Supreme Court. And in all of these courts, in each and every one of these courts, you never get a signed order. Okay, so that means 98% of our people who go to these courts, who pay an appeal at the Maryland Court of Special Appeals costs between $8,000 and $12,000, the minimum. Okay, appeal to U.S. Court of Appeals is $30,000. An appeal to the Supreme Court, by the time you get there, you've got $150,000 minimum. Okay, and for this money, you are supposed to realize that you are not allowed a signed order. Okay? I personally went to a judicial conference and asked Chief Justice Bell and Chief Justice Murphy and the members who were teaching the class exactly if they had recordings in these secret rooms where they have, and if the public was entitled to them. And this was on June 7, 2000. I paid for, it was an appellate conference for held in Baltimore, Maryland, and I paid my fee, and I went down there with about 300 other lawyers, and I asked him point blank, and he says, no, these recordings are not. That's secret justice, the Constitution. So these courts will be courts of law. I mean, courts of record. The appellate courts are courts of record. Now, we'll read that into you in a second, but this shows you what's happening. I mean, would you surrender everything you've got without a signed order? You've got one right there in front of you. They're expecting you to give up everything you've got, okay? And when you go on appeal, and you've paid big bucks for this, I mean, they've already got you down on record as your cost of being $290,000 to this point.
Right. Mm-hmm.
I mean, whoa. I just can't, it's hard for me to believe that you're not a saint. It's hard for me to believe that you're not a saint because obviously you've been fighting this matter for a long time,
well,
and $290,000 in judgment orders for cost.
I say the battle is not my battle, but it's the Lord, and Jesus Christ is my counsel, and that he's been propping me up and carrying me and shielding me and protecting me.
Yes, he has. But, you know, he's also given you something that, you know, that's unbelievable. He's given you the will to fight, okay?
Well,
he's giving
whatever
you...
he wants you to do, he'll equip you. He will equip you to do the job, because I'm just an ordinary, you know, person that has had some horrible things that have happened through no cause of her own, that he has been carrying me. And when I couldn't carry myself, you know, he propped me up and told me that just rest, just abide, and that, you know, give it some time and that it would all be okay.
Well, you know, once
and
again...
that I had to respect, and he said that I had to respect the process. He says it's flawed, but he says I've got to respect the process because it's all that we have to work with. Well,
right here, back again, folks, to the Maryland Constitution. Okay? These are the laws that we're governed by. Article 4, Section 1, the Maryland Constitution. This is what it says. The judicial powers of this state is vested in the Court of Appeals, okay, intermediate courts of appeals, the General Assembly, as the General Assembly may create by law, circuit court, orphans courts, district courts. These courts shall all be courts of record, and each shall have a seal, okay, that they use in the authentication of all processes issuing from it. Now, this was ratified by the General Assembly. This is the law. Miss Minion, you're sitting here. Does this look like a seal?
No.
Okay.
No.
Now, if you read,
it almost disappeared.
Well, that's what I'm saying. If you read the Universal Commercial Code, you'll see that 1-201, 1-203, there has to be a sign. Somebody has to attest to that seal. They have to put a date on it, and it has to have a raised seal on it. None of this is happening in our courts. How many of our citizens have to lose everything they've got before the courts wake up? They can't do this. The Supreme Court can't do this. The Maryland Court of Appeals can't do it. The Maryland Court of Special Appeals can't do it. And why in the world is the American Bar Association sitting back there and allowing them to destroy people like Shirley Binion, myself, and others?
But I have to say that I see a change in the courthouse. since I filed in '98, and
You heard it from Radhika Rishi. She's never been given equal access to the courts. She's been denied justice in every court she has entered into. The Maryland Court of Appeals is covering up for the criminal misconduct of its lawyers and judges. Nobody in the Maryland legislature will return her calls. No one she asks will help her get her property back. If this isn't predatory lending, I would sure like to know from this committee what is. The third victim is Miss Dorothy Binion. She has been fighting a fight for years trying to bring criminals who stole her business and were using it as a predatory lending firm to justice. The Prince George's County Circuit Court has frustrated all justice. The Maryland Court of Special Appeals has frustrated every effort she has to get her property back. The Maryland Court of Appeals has done it once again, and once again we have Judge Peter J. Massetti at the heart of this thing. Judge Massetti and Judge Chasnow of the United States District Court and the United States Bankruptcy Court are all intricately involved in this fraud and scam on the citizens of the state of Maryland. We need action now by our state legislators. Please pass Delegate Vaughn's House bill. God bless. The final victim is George E. McDermott. The video will speak for itself. He is currently trying to reopen all the court cases, which are now approximately 100 of them emanating out of the first fraud. Once again, Judge Peter J. Massetti is involved. The United States Bankruptcy Court's involved. Judge Chasnow is involved. The Prince George's County Circuit Court is involved. All the judges are covering up for the corrupt activities of predatory lenders and their lawyer agents and professional corporations who have no respect whatsoever for the Truth in Lending Act, for the Maryland commercial laws, and for the Maryland financial laws. We need help now. Please, please reconsider and vote yes for Delegate Vaughn's sponsored bill against predatory lending. I need this bill. House Bill number 1481. The citizens of the state of Maryland need this bill, and we need it now. God bless and have a good day.
Okay, you don't have to have it's going to be part of the record. You can submit it. It'll be part of the record. It's not.
But it's already, I've already documented in with the court earlier today.
Okay.
Based on this type of behavior.
You can submit it, and you can submit it. It becomes part of the record.
Okay.
The reason that it won't be marked for an exhibit is because if it's marked for an exhibit, it becomes part of the evidence. And so, of course, the open statement is not evidence. It's sort of like a presentation or preview of the evidence.
Okay. Well, then I will read it into the record, if you don't mind, sir. Okay. Opening statement for hearing of January 23rd, 2004, Prince George's County Court, case CAAL 9513288, recovery of property and legal rights.
Your Honor, sorry to interrupt him, but if it would save time, if he's not going to read it, I would allow it to be presented as long as it's presented with the caveat that it is an opening statement and has no evidentiary value.
If he's going to allow it to be admitted, Your Honor, it should be evidence. Otherwise, I would like to put it on the record.
Why don't you go ahead and read it?
Okay, thank you. And I typed this out in bold so that I read slow, so bear with me. Good morning, Your Honor. George McDermott, pro se defendant, appearing here today pursuant to your order of November 5th, 2003, on defendant's motion to compel plaintiffs and their counsel to give reasons why they should not be sanctioned for failure to obey direct court order of this court. For the record, will the court be addressing any of the other motions that are outstanding in today's proceedings? As the record will reflect, there are many matters still outstanding which need to be addressed at this time and should be addressed as to protect the official appellate record should it be necessary to move for appeal of this court's ruling, and we've already addressed that, I believe. The opening statement. Your Honor, we are once again here in your courtroom seeking relief from unjust, unethical judgment liens and judgments placed against the plaintiffs and their counsel and his clients who have caused the placement of, that have caused to be placed against defendant's property and the co-defendant's property and that of co-defendant in this action in bad faith and without the defendant's knowledge and or consent, let alone factual legal basis. Defendants would now move the motion in limine, which was filed with this court on January 13th, 04, now be entered into the record under the best evidence rule. 2-424, also the law of evidence, rule 5-1000 through 5-1008B. The party opponents and their counsel have failed to file any proper responsive pleading seeking to deny admission of facts contained in the record extract, Milton versus County of United Owners, Council of United Owners, is page 432 of the, which I would like to refer hereafter as Exhibit 1, the motion in limine. As of today, I got a copy this morning of the docket of the court. The plaintiffs had plenty of time to respond to the motion had they not wanted placed into evidence, and they have failed to respond, so I would now ask that the court take judicial notice of the official documents that were furnished, and here are the originals if the court wishes to examine them. Defendant now asks that the court take judicial notice of the authenticated triple seal documents and true tested documents contained within the aforementioned motion in limine as the best evidence and record of this court to consider. In that plaintiffs and their counsel have once again failed to respond to legal discovery as evidenced by the motion filed on January 16th, 04, under Rule 1-202X and 1-341, which supports defendant's claims of relief. The defendant would argue that the court rules under 5-401 support the admission of such relevant evidence, which means evidence having a tendency to make the existence of a fact that is of consequence to determination of the action more probable or less probable than it would be without the evidence of the record. The reason we are here today is that plaintiffs and their counsel of record did knowingly, with criminal intent, initiate this action in the utmost bad faith against defendants as the evidence of the motion in limine, which clearly proves that hereafter defendant would like to have referred to as Defense Exhibit 1, as it is the most complete record of the untruthfulness of the plaintiffs and agents' lack of truthfulness to this court. Your Honor, what is truth? The American Heritage The American Heritage Dictionary defines truth as most commonly meaning an agreement with facts or fidelity to an original standard. In this instance case, it would mean adherence to the statutory rules and laws of this court and nation. The court must surely realize that the statutory rules of which judicial proceedings are governed and the truth is that which is good for humanity and that which is false. The court might ask, what is truth and what is not truth? Let's look at it negatively. Primarily, the primary cause of the plaintiff's case against defendants have collapsed. It is because they are honeycombed with false statements, corporate fraud, deceit, collusion, dishonor on this court and plaintiffs by the plaintiffs against defendants, exhibits 1 through 400, which are the truth as it has been recorded and verified by this very court. The plaintiff and their counsel have built their case on an elaborate scheme of lies, false statements, forged contracts, unsigned agreements, laced with deceit, fraud on the court for many years, and built an elaborate house of cards without ever producing one bit of legal documentary, bit of legal discovery, or one legitimate court order, nor any evidence whatsoever that their claims of relief were not initiated in bad faith. If I may now walk the court through the triple seal documents which are the official record of the court and this point of recorded history, an action against defendants and other victims. Maybe the court will be able to ascertain the truth of the matter asserted as to who is lying to the court and who is not, unless the court rejects its own authenticated record. The following facts can be proved by defendant in plaintiff's own acknowledged documents, Exhibit 1, which plaintiffs having sufficient opportunity have chosen not to object formally to admission prior to these proceedings, Exhibits 1 through 400. It should be Exhibit 1 through 400. Are the plaintiffs the true holders of the alleged First American note? The answer is no, for the following reasons. The plaintiffs used embezzled money to allegedly purchase the note, which they are now trying to execute a judgment on, as Exhibits 1, Sub-Exhibits 22, 26, 73, 157, 177, 189, 200, 244, and 276 all attest, all these records, 276 all attest, all these records, recorded proceedings, state affirmatively that the plaintiffs acted in bad faith and have not been truthful with this court. Do the plaintiffs and their counsel have a history of bad faith proceedings in this and other courts? The answer is yes. This is asserted by exhibits, Exhibit 1, Sub-Exhibit 5, 23, 26, 35, 41, and 47, including other complaints and outstanding judgments, Exhibits 53, Exhibit 1, Sub-Exhibit 53. Nothing noting outstanding judgments lodged against plaintiffs, Exhibit 1, Sub-Exhibit 62, which attest to their criminal history, which was furnished to this court, which was furnished to the U.S. Attorney attesting to their crimes against the defendant. Exhibit 1, Sub-Exhibit 73. Is there any likelihood whatsoever that the plaintiffs and insiders acted in the absence of fraud with dealing with insiders bankrupt Andrew Clifford Moore? Why does the defendant say this? The bankruptcy court was never notified of the debtor's illegal actions, Exhibit 1, Sub-Exhibit 26. The existence of fact and non-compliance with the rule necessary for relief under 11 U.S.C. 1001. Exhibit 1, Sub-Exhibits 26, 67, 72, 362, 364, 366, 367, 368, and 370. And finally, 371, the promissory note which plaintiffs are pressing against defendants. Did the plaintiffs and their counsel have knowledge that if the truth were ever revealed about their alleged purchase agreement, that they would be liable for deceiving the court? Once again, the answer is yes. Peter Parker, Esquire, was once so prominent an attorney that he counseled the Vice President of the United States in impeachment proceedings, drafting and execution of the infamous August 9, 1994 purchase agreement. Exhibit 1, Sub-Exhibits 310, 321, 322, 323, 336, and 337. A document that has proven to be a fraud by three separate juries to this date. Exhibits 1, Sub-Exhibit 168, 19, and 134. It says here I must read that clause in there. So if you
just hold on a second.
Okay.
Wait,
Should I finish the opening statement?
No, 1 second. Yeah, you can hold on a second. This room, can you ask Amy to let Master Sparrow and Judge Shelby know that they have to do the best they can to help? You may continue.
Okay. Further ado, I'll come back to this must read after I finish the statement, if you don't mind. With no objection. Your Honor, this defendant and I assume co-defendants counsel are seeking emergency relief from this court to make plaintiffs and their counsel and insiders comply with the lawful discovery rules of this court, Exhibits 73 through 78, and Exhibits B1, which will be admitted later, through 3. Further, defendants respectfully request that this court issues an order nullifying all judgment liens in favor of plaintiffs against defendants listed in Exhibits 179 through 359.
I'm going to interrupt you just a little bit right here.
Yes.
Because this is the best opportunity for me to get some clarification. You're talking about these liens, are they liens that come out of this specific case, CAL 95-13288?
Yes, they are. They are liens that were that in prior court proceedings, which are recorded here,
Okay, no.
were
Okay, here's the question. Not prior court proceedings. Well,
No,
they come out of this specific case.
They come out of this specific case, Your Honor, because they were liens that they have attested to in their own documents that they've satisfied, and yet they've transfer these documents to inside attorneys to file judgments against me and to encumber $330,000 of my property and force me into receivership.
And that is quote unquote evidence.
That is evidence that is in Exhibit 1 without
this, that you're going to, I mean, how are you ever going to get that person through? And it does go to this constitutional case as being considered by the Supreme Court now on the flag salute of one nation under God. Here was a continuation of a discovered set of laws that somehow discovered that our children can't say the flag salute because it's one nation under God, that 90% plus of the public is for the flag salute. I'm quite confident it's ahead of that when this body raised such outrage, and yet the Ninth Circuit, in a consistent opinion with 40 years of discovering law, says no, you can't do that. So now you put somebody in a legislative role, circuit court, lifetime appointment, can't remove them, Ninth Circuit. Ninth Circuit gets overturned all the time. I mean, as a group of legislators, they get overturned all the time by the Supreme Court. But now let's say you get a Supreme Court position that opens up. They're not going to get overturned by anybody. And you get people very fearful of the tyranny of a judiciary, which the Founding Fathers were fearful of themselves. You know, they were saying of all the branches of government, they wanted the judiciary to be the most limited because they had these lifetime appointments. They had a pretty big set of powers, and they feared that tyranny coming from the judiciary because it was a lifetime appointment. It was something that wasn't subject back to the people and the checks and balances of the people. People check and balance the president. People check and balance me. People check and balance everybody that are in this body. But do they the judiciary? Where's the populace's check and balance here? And that's why this is an important debate, and that's why so many...
Without a doubt, it's triple sealed by the court, and there's no way they can refute it. Their contracts are in there, and their judgments are in there, and credit statements are in there to attest to this. So...
How long you get back on track?
Okay. Your Honor, this defendant, and I assume, okay, I'll go to that. Further, defendant respectfully requests that the court issue an order nullifying all the judgments, blah, 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 through 159. Also, exhibits B and C as plaintiffs acknowledged writing exonerate the existence of these alleged judgments and the truths of proofs, it should be proofs of fraud, truth, that fraud has been committed on this court. Beyond any reasonable doubt, there is no reason why the defendant should pay approximately $10,000 a year in predatory interest loans, taxes, and upkeep on personal properties that plaintiffs and their counsel have encumbered. Okay? Because the courts cannot recognize a fraud when it sees it. Defendant will also note that all court judgments and costs assessed against defendants by the Circuit Court of Prince George's County, the Maryland Court of Special Appeals, and the Maryland Court of Appeals. As the court's clerks have refused defendants access to the official file jackets of these courts to and until such time as Leslie D. Gurdett and Chief Justice Murphy have time to review the file, and this is a quote from the clerk's office, to review the file and remove sensitive documents from the appellate court file prior to me looking at my own case. And this was it was witnessed by a witness yesterday and captured on videotape on 122. They can maintain positions as appellate judges in any court. The court cannot refute that defendants are only are the only persons being held liable for partnership assets and the only persons who have lawful claims to those assets, irrespective of any fraudulent agreement, contract, conveyance, insiders and their counsel may have put before these and other courts. No one has to tell the court its duty, obligation to uphold the defendant's constitutional rights, to uphold the defendant's constitutional rights and rights of litigants appearing before it, and that the court has a further statutory obligation as defined under Title 18 of the United States Criminal Code to make sure that persons who use the courts to commit fraud are brought to swift and absolute accountability for their crimes and are not allowed to escape the long arm of the law. Because they have Exhibit 1, Sub-Exhibit 401, 405, 406, 408, 419, 425, and 431. In closing, the defendant would ask that this court freeze all assets of plaintiffs and their counsel until such time as an evidentiary hearing is held to determine the legal ownership of Crystal Skates Limited Partnership's assets, now in control and custody of plaintiffs and their insider Andrew Moore. Further, the defendant would move this court to grant a $1 million judgment for court costs against the plaintiffs and their counsels jointly and severally for betraying the court's trust and bringing fraud into the court, and that such judgment be held to be paid within 30 days. Finally, the defendant would ask that the court notify the Maryland State's Attorney, the Honorable Glenn Ivey, and notify the Maryland State's Attorney, the Honorable Glenn Ivey, and ask for a grand jury be convened to investigate and bring charges against plaintiffs and their counsels and insiders under Article 27 of the Maryland Criminal Code, to include charges of embezzlement, extortion, insider trading, perjury, falsification of corporate documents, conspiracy to defraud both Maryland and state federal taxing authorities, as plaintiffs have already been found guilty of in previous cases. Exhibit 1, Sub-Exhibit A, 51, 53, 363, 63, 64, 65, 66, 67, 68, 69, and 70. Defendant moves that this entire statement be made part of the official court record of these proceedings and is proof of the affirmative defense put forth by defendant. A copy of this statement and video copy of the proceedings will be sent to the U.S. Attorney's Office in New York seeking a federal grand jury investigation in corporate fraud and insider trading by plaintiffs and their counsels and the plaintiffs' agents and assigns pursuant to 18 U.S.C. 3057. Respectfully submitted, George McDermott. Let's see into my statement, Your Honor.
Before I turn to Mr. Morgan on the plan, Mr. McDermott, although I tried as best I can to prefer a particular case, you filed a motion in limine and it includes 400 pages at least. And during your opening statement, I perceive you to be saying that that document contains what you would rely upon for the court to exercise its power to reopen this case. Is
That's absolutely...
It contains everything that you would rely upon to present it to the court?
Everything that I know of, Your Honor, because you have to realize, for 10 years, I have been prosecuted in this court, the plaintiffs and their counsel and their insiders have never answered any in this court. We have never The plaintiffs and their counsel and their insiders have never answered any discovery. So for right now, I have to rely on the record of this court and the appellate court record.
Let me hear from Mr. Harden. And I asked that question in part because the court, if that's what's relied upon, the court would probably have to pore over what's there.
I assume that would be, that this would not be a resolved today, Your Honor.
That would good if Evelyn would. But let me hear from Mr. Harden.
Judge, the stated purpose of this hearing, as I heard earlier, that was agreed to by the plaintiff and defendant in the court, was for you to initially decide the defendant's motion to reopen. After hearing that opening statement, I will just say that it's my position that it's a simple regurgitation of the arguments that I have heard time and time again, and is not in any way, shape, or form sufficient to have the court reopen this case for the reasons stated in the statute. These arguments were all made and have been made for the last 10 years to anyone who Mr. McDermott can find a pair of ears. Once again, I have seen nothing that's new, nothing that proves there is any new evidence, nothing that proves that there is any fraud. It's all the same stuff that we've heard time and time again. I think that the court can review anything it wants to review. We don't respond to Mr. McDermott's thousands and thousands of documents that he bombards us with, because they make no sense at all to me. As a lawyer, perhaps some consider me a competent lawyer, I cannot make head or tails out of what he's arguing and what relief he wants. But I do know that this case has long ago been closed and appealed and statistically closed by Judge Smith, and despite that, Mr. McDermott continues to file these motions. Therefore, the motion to reopen the case that I think is before the court must fail. He has not demonstrated anything. He has not brought forth any new evidence that's relevant to this case. There is a complaint in this case. The issues in that complaint have been resolved long ago, and now we're talking about, you know, Attorney General's investigations in New York and $1 million in I mean, I don't even, again, I apologize, but I don't even understand what Mr. McDermott is arguing here. But what I do understand is that this case has long since been closed. The court's job at this juncture is to determine if there's any newly discovered evidence that would bear on the issues in this case, and if not, the defendant hasn't met his burden and would ask you to, once and all, deny their motions and close the case out.
I'll respond, Your Honor. Yes. Well, and Your Honor, the Court of Appeals docket clearly indicates that that Judge Smith and this court had no jurisdiction to dismiss the case because the mandate was on travel back here, and the case had not reached this court for the dismissal order. The second thing is Judge Smith is a relative of Peter Parker's, which has been attested to, and there are U.S. District Court cases in here in which Winnie Barefoot gave me verbal testimony that Judge Smith was the brother-in-law of Peter Parker. And she's been to family functions with him. She's taken pictures of him. She described how he was using the offshore banks in the Bahamas, in Longboat Key, Bahamas, where he was using my skating rink to launder money out of the Miami drug cartel and transport it into the Bahamas in special altered suits. She's his neighbor down there. She was also a victim up here, and the court records show that she was responsible for having Mr. Parker incarcerated for fraud in the previous cases she was involved in where he forged documents and without her knowledge and consent and stole millions of dollars from her. So that is within this document here, Your Honor. It's sealed by the U.S. District Court in Greenbelt, and it can't be refuted. Now, everybody knows that due process of the law means that you have rights in the court of law, and that no judge, whenever there's any evidence whatsoever slight that he's part of the, one of the parties, that he should step down. I've asked for his removal and the case to be reassigned time and time and time again. Mr. Harding seems to believe that my motions make no sense. My arguments make no sense, but yet I've defeated him in 3 trials. 2 of them I argued myself. One before Judge Smith, it's on videotape. Then Judge Smith, after the jury comes back, and by the way, all 3 of these trials was overturned by Judge Smith in secret, not on the record, in secret, after they were awarded. Okay? Now, I'm a victim of legal malpractice. Mr. McDermott back here is a victim of legal malpractice. My other 40 partners are victims of legal malpractice. That's legal malpractice. Mr. Harding, he knows the law.
Mr. McDermott, I'm not going to...
Okay.
I'm going to object. Thank you.
Okay. Okay. Their law firm represented, they represented Andrew Moore. Last Friday when I delivered the last motion, who do I run into in the lobby of their office? Mr. Moore, his first client, even though he never applied for, with the U.S. Bankruptcy Court to be a client of record, attorney of record. That was his first client in Judge Smith's 95-940 case. Okay? Each and every case that has got anywhere near settlement, they have lost. Relied on insiders within the court system to frustrate justice and overturn the verdict and squeeze myself, my wife, and my partners into submission. Now, it's very simple. It's a fraud's been committed. Now, he says it is irrelevant. 18 U.S.C. 3057 says it's an obligation for an attorney, accountant, receiver, a judge. I didn't know until just recently that, well, Dennis Peters in the U.S. Attorney's Office is related to Charles J. Peters in the U.S. Attorney's Office is related to Dennis Peters, who initiated the loan documents that are now before this court. Okay? Tamara Fine in the U.S. Attorney's Office is purportedly related to Howard Fine, who took the titles to my home after they were released from Nations Bank and First Union Bank and re-recorded them as security for a loan for plaintiff's business. That's a matter of fact. And just yesterday when I was down at the Court of Appeals, I no longer notice on the wall, here's a big sticker. And it makes my mind think. Judge Moore of the Maryland Court of Appeals. What, is there a connection here now? Is this why the court won't let me see the official document, why there is no public document in that record, in that court? That somebody in that court is influencing decisions? And going back to the Court of Appeals opinion, which we won 5 years ago, I go back into the court and I ask for a copy of the transcript because they record the proceedings, and they tell me that the Maryland Court of Appeals is, well, that, I'm sorry, Your Honor, this document right here says they have to. That's the Constitution. It says these courts will be governed as courts of record. Now the record's here. The record is here. Here's the mandate. I would like to enter into the Court of Appeals record as of yesterday as a defense exhibit 1 at this time. Have it marked for you.
What we're going to do.
Okay.
Here, what else you have to speak? Open statement.
Well, my opening statement is they cannot assert, nobody can assert that there's not grounds for new evidence. The fact that I have $360,000 worth of my personal property encumbered by loans and judgments in favor of plaintiffs refutes the alleged August 9th agreement, which they allegedly entered into, in which the plaintiffs were not even a corporation to exercise. They didn't become a legal entity until August 23rd of that year.
Let me say this from a preliminary standpoint. We have to see from all of this. There is one motion that I can act on right now, and then I'll suggest to the parties what the court intends to do on the other matters. There was filed on November the 18th, which is a document 196. We have to see from all of this. There is one motion that I can act on right now, and then I'll suggest to the parties what the court intends to do on the other matters. There was filed on November the 18th, which is a document 196, a motion of second-class citizen to the court requesting that the proposed hearing be scheduled in a courtroom having video transcript, and further that the defendant request the court clerk and documents requested on November 7, 2003 are triple sealed by court at the defendant's expense, that the court may take judicial notice of these documents. So you got some documents triple sealed.
I've got all the judgments that were recorded against me because of and each one was a result.
Here's a question, Mr. Montgomery. The triple sealed documents you requested, you have it. You have it.
Right there for you. And you have a copy in the motion in limine.
That's part of it. Now, I can address the first part of this motion, although it's the type of motion that would appear to be most appropriate before Judge Missouri. And on many things, we have the power to deny, we don't have the power to grant. The motion your motion requesting that the proposed hearing be scheduled in the courtroom having video transcript, I'm denying it for these particular reasons. This is a Friday, and I'm in this court. All of our civil matters are considered here. Not all of them, depends on availability.
Your Honor, I fully understand that the court's under renovation, and what has happened has happened. We have a video audio transcript of this anyhow. So that motion is basically moved at this point anyhow, and I agree.
That's the thing I have over here, and I ignored them. Now, with the other matters, I have some notes right here. It seems as though before we get into everything else that I need, as a court, I need to pour over your exhibit number 1 that you've been referring to. It hasn't been marked here. Your exhibit number 1, your file and everything here that's part of your motion to me. I need to pour over all the attachments in there. Now, my notes now disclose part of my mind to you right now because this is all I'm going to read from it. I have to pour over defendant's exhibit number 1. I have to examine the forums. I mean, when I said forums right here, when I heard your opening statement, I heard allegations of malpractice. I heard things need to be investigated one place or the other needs to be referred. So when I think about the forum, it seems as though you were inviting the court to examine a lot of issues that may not necessarily be within the court's bailiwick. Then I have examined the scope of relief, which means that it's part of the same thing. What's being asked, and part of my examination of the scope of relief means that I think the court has an obligation to look and see, assuming that the motion to reopen would be granted, what is open, because to the court, what would be open would be the complaint or the note, the filing that initially came into the court, any response that there was in terms of if there was a counter complaint, and it's been so long I can't remember if there was a counter complaint.
No, hundreds of.
And what type of relief, what was the scope of this specific case, Now, when I look at issues, for instance, examine the form and the scope of relief, I heard you say in your opening statement and also in response, further to your rebuttal opening statement, I heard you express concern that our appellate courts have not acted constitutionally or appropriate. And being a member of an inferior court, that becomes one of the forum questions. I've heard complaints that Judge Smith might have some issues that might relate to professional ethics, and so when I look at that, I'm saying to myself, is that a form, is that something that goes to Sally Atkins, or she's the chairman of the Commission on Judicial Disabilities. So I think I have the responsibility to look and see exactly how much is being asked for, that even before I can narrow it down to make certain I can answer the ultimate question, which we learn in law school to make very narrow. You got a lot of concerns. And
well, after 13 years of being kicked.
I want the time right now. So, and I'm not questioning the legitimacy of those terms, those concerns. It's just that we're always taught to narrowly consider an issue, and that's the legal mind. Okay. And then I've got to say reviewing what actions ought to be set aside, and I've got to also rule on the further hearing. And I think with what we have here today, if I'm allowed by both parties to have you filed that before, and I have a copy of it, but to have the court review the attachment to the motion in limine, without anybody saying, there's some question about even what I can accept as being true or what I can't. You've asked for judicial notice. I probably need the package of sealed documents, triple sealed documents.
No problem.
And I need to look at your other two motions, and I need to look at it in the context of the materials that you're submitting.
Yeah.
And we need to have, and then I need to decide at that point in time how we're going to proceed, or whether or not I place it in a posture so you can have my action reviewed by someone else. You need to have I need to have a sense of where we're going, and you need to have a sense of how the court is looking at matters, I think.
I agree there, Your Honor, and this is a very difficult situation for the court to be in. It's a situation the court never, ever should be in. It's a long-standing judgment, but you've got to realize that each day that goes by, I am being penalized because I have to pay roughly $15,000 a year in taxes on my property, and upkeep on my property, and exorbitant interest rates to credit card companies because I borrowed in good faith and I made good on all my obligations. I have lost my business. I haven't worked in 3 years. I took off. I do a little bit of work, but I haven't really received a paycheck in 3 years because 100% of what I have goes towards getting him back his property.
Let me ask you this question. Would the court allow it? When I look at things, I look at them closely. I get a chance to. Would the parties allow the court to do that examination? You may take me 30 days so to get the things done. I've got to look at everything I can, one way or the other, because whatever I do, I want to make certain the record is very clear as to what I've done, so that both parties will have something that they can create a record of, a focus for any appellate court.
Without objection from me, Your Honor.
And what I'll do, I'll rule in there, and we'll have to set a new hearing, on other matters. In the interim, the court is staying in a formal discovery.
It's staying, Your Honor? Could I ask on what grounds? How can you possibly...
Okay, I'm not going to argue with Ms. McDermott.
Okay.
Until this case is reopened, until we know that the case is still alive and has been revived, until we know that the case has been revived, the court is concerned because a failure to comply with discovery allows a party to file a motion for contempt, and it allows the court to do a lot of things. It allows the party to file a protective order that says, we don't even know if the case is reopened yet. So I need to do that, and I have to do it.
Okay. This won't preclude. I'm in Virginia where they executed these notes.
Well, I can't.
But that I have to go forward. All I did is I'm here to perfect the record now, because, you know, and I can live with whatever the financial consequences are, but the court must know that this is ongoing. This crime has not stopped. Each day, judgment costs are costing myself and my family just as if they went out with a gun and held me up for $400 a day every day when I walked out of my house. These attorneys are doing that to me. And so I have to take what actions are necessary and prudent to protect myself and my investors.
Okay, so docket entry B of the...
I have a copy of today's docket right here. And as of today, they have not, you know, and if I may, Your Honor, one question.
No, sir, 1 second. What I need to do is put this in. 187, docket entry 187, this will allow you to pull it out. 187, 182, and 208 are taken under advisement for the issuance of a ruling and a determination of whether a further hearing will be set. I'm going to try to get it done within 30 days. I'm going to try to get it done within 30 days. I promised somebody something that's going to be within last Tuesday, and they don't have it yet. But
I understand the constraints on the court's time.
And I'll give you a written opinion or a written assessment of what I think the issues are, what might be still left.
Okay, Your Honor, I would like to...
May we be excused now?
No, sir, Your Honor, please. I would like...
Your Honor, may I be heard at this point in time?
Okay, what are you about to ask of Mr.
Well, Your Honor, I would like to call Mr. McDermott to up to the stand to answer one question in open court for you, and that's it.
Question?
Mr. McDermott...
No. Tell me what the question is, Mr. McDermott.
Okay. Simply as, you know, in rebuttal to this outrageous opinion of the Court of Appeals, at what point in time, if he's aware of any point in time, if he's aware of any specific point in time that I walked away from $2 million worth of assets and his interest.
No, I'm not going to let that question be asked.
You're not going to allow that? Okay, well, because that's the most relevant question we've got here, because I'm the only stockholder.
It defies common sense that you walk away from that, but at the same time, our language is a rich language, and a lot of liberties taken with the language by a lot of people, including me, and so the context of an opinion is
well, he's a stockholder. He's a stockholder.
Sir,
please.
Yes, Your Honor, the court has ruled. My prior experience is that Mr. McDermott will continue to go on, if allowed, for many, many more hours. I would ask to be excused at this time if the proceeding is over. If the court wouldn't mind, I would like to move on.
Mr. McDermott has some time generally responsive to my request, so I'm going to do what I'm going to do. I'm going to look at all the stuff right there. The triple seal documents are included within the binder, correct?
Yes, sir. Only one new document was a fax from me from HFC yesterday that shows that as of this week, they still have the
I'm going to rely on what's been filed at this point in time.
Okay.
Thank you.
God bless. Have a good day, Your Honor.
Thank you. Nice to see you, Judge.
predatory lenders and their lawyer agents and professional corporations who have no respect whatsoever for the Truth in Lending Act, for the Maryland commercial laws, and for the Maryland financial laws. We need help now. Please, please reconsider and vote yes for Delegate Vaughn's sponsored bill against predatory lending. House Bill number 1481. The citizens of the state of Maryland need this bill, and we need it now. God bless and have a good day.